All right, live, chapter 11, screening the prosecutor's charging decision. An innocent individual subjected to a trial pays a substantial price, even though acquitted. Being accused of a serious crime creates a blot on one's reputation that may not be fully erased by an acquittal. Even where the acquittal does provide full vindication, it does not remedy other burdens borne in the course of gaining that vindication. Once accused, the defendant must await trial, a process that brings with it a degree of anxiety and insecurity that disrupts the flow of daily life. The trial itself is even more of an ordeal and carries with it a significant expense. In light of these burdens, it is not surprising that a criminal justice process concerned with the protection of the innocent will incorporate safeguards that go beyond ensuring against erroneous convictions and seek also to ensure that unfounded charges are not being brought against the innocent. A major element of such protection comes from the requirement that the prosecution's decision to charge be reviewed by some neutral agency. That agency generally is either the grand jury that screens the prosecution's case in deciding whether to indict, or the magistrate who is determined at the preliminary hearing whether a charge has sufficient support to be sent forward to the next step in the process. So, reviewed by a neutral agency, which is either the grand jury or the magistrate at the preliminary hearing. The Fifth Amendment provides that, except in certain military cases, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. It thus guarantees to any potential defendant in a federal criminal case involving an infamous offense held to encompass all felony offenses that no charge will be brought against him without the concurrence of a group of his peers, as expressed in the decision of the grand jury to issue an indictment. The alternative form of accusation, the presentment, which was issued at the grand jury's own initiative, is no longer used. In requiring prosecution by indictment, the Fifth Amendment interposes the grand jury between the prosecutor and the prospective defendant. And casts upon it a shielding function. The classic description of that function is found in Wood v. Georgia, 1962. Historically, this body, the grand jury, has been regarded as primary security to the innocent against hasty, malicious, or oppressive prosecution. It serves the invaluable function in our society of standing between the accuser and the accused, whether the latter be an individual, minority group, or other, to determine whether the charge is founded upon reason or was dictated by an intimidating power or by malice and personal ill will. At the time of the adoption of the Fifth Amendment, all of the states also required that felony prosecutions be brought by indictment. In the mid-1800s, however, several of the newer states shifted from prosecution by grand jury indictment to prosecution by an information, an accusation issued by the prosecutor rather than the grand jury. To ensure independent screening, those states restricted the use of the information to cases in which the magistrate made finding a probable cause in support of the information at the preliminary hearing. That came from, doesn't say. In Hurtado v. California, 1884, that procedure was sustained against constitutional challenge. The Supreme Court there held that the guarantee of prosecution by grand jury indictment, though found in the Fifth Amendment, did not reflect a fundamental principle of liberty and justice, and therefore was not applicable to states under the due process clause of the 14th Amendment. Okay, that's huge. Although the Supreme Court, with the adoption of in the 1960s of a different view of the 14th Amendment, generally overruled its earlier decisions that had refused to find in due process of right specified in the Bill of Rights. See Chapter 2, Section 1. The Hurtado ruling provided that one major exception to that pattern. The court has continued to hold that the states need not prosecute by indictment, and today only about 20 states still require grand jury review. In the remaining states, the prosecution may proceed by indictment or information, and most prosecutors in those states proceed by information in most cases. In the vast majority of the states allowing prosecution by information at the prosecutor's discretion, the information can be filed only if there has been a determination of probable cause by a magistrate at the preliminary hearing. Defense counsel generally view this requirement as providing a more favorable screening process than the grand jury because the preliminary hearing is an adversary proceeding at which the defense may cross-examine the prosecution's witness. This and present its own evidence. This stands in contrast to the secret and non-adversary grand jury proceeding in which only the prosecution participates, presenting its side of the case and serving as a legal advisor to the lay jurors. The preliminary hearing also may provide the defense with other procedural advantages, as noted in Coleman v. Alabama Infra. There's some footnotes here. These jurisdictions commonly allow for defense waiver of the indictment, so a felony prosecution can be brought by information in such states where the defendant makes a proper waiver of his right to grand jury review. These jurisdictions also allow for defense waiver of the preliminary hearing, so felony information can be filed without a magistrate's probable cause determination when there has been a waiver. Jurisdictions requiring prosecution by indictment also provide for a preliminary hearing in felony cases within a specified period after arrest, but that hearing will not be held if an indictment is obtained prior to the scheduled date of hearing. The indictment establishes probable cause as found by the grand jury, and since the grand jury finding prevails over any determination to the contrary that the magistrate might make, there is no need for a preliminary hearing. In some indictment jurisdictions, it is common for prosecutors to bypass the preliminary hearing by first obtaining an indictment. While the practice in other jurisdictions is to have a prompt preliminary hearing followed by the taking of the case to the grand jury. The latter practice was followed in Coleman v. Alabama. That's interesting. In a few states allowing prosecution by information, the prosecution has available the option of direct filing of the information without a preliminary hearing. Because the practice upheld in Hurtado required a preliminary hearing, it was not clear from that case whether due process permitted the state to utilize an accusatory process at the in a felony case that dispensed with any form of screening procedure by a neutral agency. That issue was presented in Len Woon v. Oregon, 1913, which presented a challenge to the direct filing of an information without any examination or commitment by a magistrate, or any verification other than the prosecutor's official oath. Relying on the fundamental fairness analysis of Hurtado, the court in Len Moon sustained the state's direct filing procedure. This court has, and this is a quote, held that the due process of law clause does not require the state to adopt the institution and procedure of a grand jury, and we are unable to see upon what theory it can be held that an examination or the opportunity for one prior to the formal accusation by a district attorney is obligated upon the states. Although the Supreme Court subsequently held in Gerstein v. Pugh, 1975, that the Fourth Amendment requires a magistrate's ex parte determination of probable cause, as in the issuance of an arrest warrant, where there is extended restraint of liberty following arrest. CFNA, page 161, the opinion there reaffirmed the holding in Lem Woon that a judicial hearing is not a prerequisite to prosecution by information. The Constitution does not require the state to provide judicial oversight or review, as in a preliminary hearing, of the decision to prosecute. Quoting Gerstein. While states are not constitutionally required to provide for screening by either the grand jury or the preliminary hearing, once they do afford such screening, constitutional limitations may apply. The first two cases in this chapter, Coleman v. Alabama and Vasquez v. Hillary, treat the two major constitutional limitations applicable to the preliminary hearing, Coleman, and the grand jury, Hillary. Those cases also raise the question of whether convictions should be reversed, where there was constitutional error in the screening process, but the defendant was then found guilty after a trial that complied in all respects with constitutional requirements. There's a footnote here about Chapman versus California. The issue posed in this regard relates to applicability of the constitutional harmless error doctrine set forth in that case. In 1967, prior to Chapman, it frequently had been assumed that all constitutional errors automatically required reversal of a conviction on appeal because such errors were per se injurious. Chapman held, however, that constitutional errors were not exempted from the usual rule of appellate review that requires affirmance where the error in prior proceedings is deemed harmless. The court reasoned that this harmless error principle served a very useful purpose insofar as it blocks setting aside convictions for small errors or defects that have little, if any, likelihood of having changed the result of the trial. Accordingly, as to most constitutional errors, reversal of a conviction would not be required where the state could establish that the error was in fact harmless. This required the state to prove beyond a reasonable doubt that the error did not contribute to the verdict obtained. The court added, however, that there are some constitutional rights so basic to a fair trial that their infraction can never be treated as a harmless error. Cited as illustrations in such errors calling for automatic reversal, where a state's failure to provide appointed counsel at trial is required under the Sixth Amendment and a due process violation resulting from the possible bias of a trial judge whose fees were derived from the fines he imposed. See Tummy v. Ohio. 8. In federal prosecutions, of course, the Fifth Amendment requires prosecution by grand jury indictment. The third case in the chapter, Costello v. United States, raises the question whether the Fifth Amendment requires that a grand jury's decision to indict be based on evidence that would be inadmissible at trial. Briefing this case. So I'm going to issue page 674. Following Costello, the Supreme Court indicated in a series of cases that the rationale of Costello was also applicable to grand jury consideration of evidence that would be inadmissible at trial because obtained in violation of the federal Constitution. In the latest of those Supreme Court rulings, United States v. Calandra, 1974, holding that a grand jury witness could not refuse to answer questions based on information obtained through an unconstitutional search. The court noted the grand jury sources of information are widely drawn, and the validity of an indictment is not affected by the character of the evidence considered. Thus, an indictment valid on its face is not subject to challenge on the grounds that the grand jury acted on the basis of inadequate or incompetent evidence, Costello v. United States, or even on the basis of information obtained in violation of a defendant's Fifth Amendment privilege against self-incrimination. So the first case in this section is titled Coleman v. Alabama from 1970. Justice Brennan delivered the opinion of the court. And since we're at 15 minutes already, okay, this will be a long one. Petitioners are convicted in an Alabama Circuit Court of assault with intent to murder in the shooting of one Reynolds after he and his wife parked their car on an Alabama highway to change flat tire. The Alabama Court of Appeals affirmed, and the Alabama Supreme Court denied review. We vacate and remand. Petitioners argue that the preliminary hearing prior to their indictment was a critical stage of the prosecution, and that Alabama's failure to provide them with appointed counsel at the hearing before unconstitutionally denied them the assistance of counsel. This court has held that a person accused of crime requires the guiding hand of counsel at every step in the proceeding against him, Powell v. Alabama, and that the constitutional principle is not limited to the presence of counsel at trial. It is central to the principle that, in addition to counsel's presence at trial, the accused is guaranteed that he need not stand alone against the state at any stage of the prosecution, formal or informal, in court or out, where counsel's absence might derogate from the accused's right to fair trial. Citing U.S. v. Wade. That's actually the issue. Okay. This court has held, so on the question of when the right to counsel arises, the principle of Powell v. Alabama in succeeding cases requires that we scrutinize any pretrial confrontation of the accused to determine whether the presence of counsel is necessary to preserve the defendant's basic right to a fair trial as affected by his right meaningfully to cross-examine the witness against him and have effective assistance of counsel at the trial itself. It calls upon us to analyze whether potential substantial prejudice to defendant's rights inheres the particular confrontation and the ability of counsel to help avoid that prejudice. Applying this test, the court has held that critical stages include the pretrial type of arraignment, where certain rights may be sacrificed or lost, Hamilton v. Alabama, and the pretrial line of U.S. v. Wade, CF Miranda v. Arizona, where the court held that a privilege against compulsory self-incrimination includes a right to counsel at a pretrial custodial interrogation. And this is for the development of the concept critical stages, or the definition of that. The preliminary hearing is not a required step in Alabama prosecution. The prosecutor may seek an indictment directly from a grand jury without a preliminary hearing. The opinion of the Alabama Court of Appeals in this case instructs us that under Alabama law, the sole purposes of a preliminary hearing are to determine whether there is sufficient evidence against the accused to warrant presenting his case to the grand jury, and if so, to fix bail if the offense is bailable. See Code of Alabama. The court continued, at the preliminary hearing, the accused is not required to advance any defenses, and failure to do so does not preclude him from availing himself to every defense he may have upon the trial of the case. Also, Pointer v. Texas bars the admission of testimony given at a pretrial proceeding where the accused did not have the benefit of cross-examination by and through counsel. Thus, nothing occurring at the preliminary hearing is in the absence of counsel can substantially prejudice the rights of the accused on trial. This court is, of course, bound by its construction of the governing Alabama law. However, from the fact that in cases where the accused has no lawyer at the hearing, the Alabama courts prohibit the state's use of trial of anything that occurred at the hearing, it does not follow that the Alabama preliminary hearing is not a critical stage of the state's criminal process. The determination whether a hearing is a critical stage required in the provision of counsel depends, as noted, upon an analysis. 1, whether potential substantial prejudice to defendant's rights adheres, and 2, confrontation and the ability of counsel to help avoid that prejudice, from U.S. v. Wade. Plainly, the guiding hand of counsel at the preliminary hearing is essential to protect the indigent accused against an erroneous and improper prosecution. First, the lawyer's skilled examination and cross-examination of witnesses may expose fatal weaknesses in the state's case that may lead the magistrate to refuse to bind the accused over. Second, in any event, a skilled interrogation of witnesses by an experienced lawyer can fashion a vital impeachment tool for use in cross-examination of the state's witnesses at trial or preserve testimony favorable to the accused of the witness who does not appear at the trial. Third, the trained counsel can more effectively discover the case the state has against his client and make possible the preparation of a proper defense to meet that case at the trial. Fourth, counsel can also be influential at the preliminary hearing in making effective arguments for the accused on such matters as the necessity for an early psychiatric examination or bail. The inability of the indigent accused on his own to realize these advantages of the lawyer's assistance compels the conclusion that the Alabama preliminary hearing is a critical stage of the state's criminal process, at which the accused is as much entitled to such aid of counsel as at the trial itself. Powell v. Alabama, quoted there. Remains then the question of the relief to which petitioners are entitled. The trial transcript indicates that the prohibition against use by the state at trial of anything that occurred at the preliminary hearing is scrupulously observed, but on the record it cannot be said whether or not petitioners were otherwise prejudiced by the absence of counsel at the preliminary hearing. That inquiry at the first instance should more properly be made by the Alabama courts. The test to be applied is whether the denial of counsel at the preliminary hearing was harmless error under Chapman v. California. We accordingly vacate the petitioner's convictions and remand the case to the Alabama courts for such proceedings not inconsistent with his opinion, as they may deem appropriate to determine whether such denial of counsel was harmless error, and therefore whether the conviction should be reinstated or a new trial order. Justice Black concurring. Justice Douglas, while I've joined. So I guess he concurs. White concurs. Harlan concurs. A lot of concurrence. 4 concurrence. Stewart and the Chief Justice dissent. Berger dissents. And what else we got? That brings us to the next case. There's 3 dissents, 4 concurrences, and the majority opinion. I'll go through the concurrences and all that. I wholeheartedly agree with the court's opinion, and this is Black, holding, in part 2 of this opinion that an accused has a constitutional right to the assistance of counsel at the preliminary hearing, which Alabama grants criminal defendants. The preliminary hearing is ... a definite part or stage of the criminal prosecution in Alabama, and the plain language of the Sixth Amendment requires that in all criminal prosecutions, the accused shall enjoy the right ... to have the assistance of counsel. For his defense, I fear that the court's opinion seems at times to proceed on the premise that the constitutional principle ultimately at stake here is not the defendant's right to counsel as guaranteed by the 6th and 14th Amendments, but rather right to a fair trial as conceived by judges. While that phrase is an appealing one, neither the Bill of Rights nor any other part of the Constitution contains it. ... Justice Douglas, while I have joined Justice Brennan's opinion, I add a word as to why I think that a strict construction of the Constitution requires the result reached. The critical words are, in all criminal prosecutions, the accused shall enjoy the right ... to have the assistance of counsel for his defense. As Mr. Justice Black states, a preliminary hearing is a definite part or stage of a criminal prosecution in Alabama. A criminal prosecution certainly does not start only when the trial starts. If the commencement of the trial were at the start of the criminal prosecution in the constitutional sense, then indigents would likely go to trial without effective representation by counsel. Lawyers for the defense need time to prepare the defense. The prosecution needs time for investigations and procedures to make that investigation timely and telling. As a shorthand expression, we have used the words critical stage to describe whether the preliminary phase of the criminal trial was part of the criminal prosecution as used in the Sixth Amendment, but it is the Sixth Amendment that controls, not our own ideas as to what an effective criminal code should provide. It did not take nearly 200 years of doubt to decide whether Alabama's preliminary hearing is a part of the criminal prosecution within the meaning of the Sixth Amendment. The question has never been reached prior to this case. If we are to adhere to the mandate of the Constitution and not give it merely the meaning which appeals to the personal taste of those who from time to time sit here, I should read its terms in light of the realities of what criminal prosecutions truly mean. It says that Black, Douglas, and White and Justice Marshall joined this part 3. All right, so White concurring. I agree with Justice Harlan that recent cases furnish ample ground for holding the preliminary hearing a critical event in the progress of a criminal case. I therefore join the opinion of the court, but with some hesitation, since requiring the appointment of counsel may result in fewer preliminary hearings in jurisdictions where the prosecutor is free to avoid them by taking a case directly to the grand jury. Our ruling may also invite eliminating the preliminary hearing system entirely. I would expect the application of the harmless error standard on remand to produce results approximating those contemplated by Mr. Justice Harlan's separately stated views. Whether denying petitioner counsel at the preliminary hearing was harmless beyond a reasonable doubt depends upon the assessment of those factors which made the denial error. But that assessment cannot ignore the fact that petitioner has been tried and found guilty by a jury. The possibility that counsel would have detected preclusive flaws in the state's probable cause showing is for all practical purposes mooted by the trial where the state produced evidence satisfying a jury of the petitioner's guilt beyond reasonable doubt. Also, it would be wholly speculative in this case to assume either one, that the state's witnesses at the trial testified inconsistently with what their testimony would have been if petitioner had counsel to cross-examine them at the preliminary hearing, or 2, that counsel, had he been present at the hearing, would have known so much more about the state's case than he actually did when he went to trial that the result of the trial might have been different. So, 2, it seems extremely unlikely that matters related to Bill or early psychiatric examination would ever raise reasonable doubts about the integrity of the trial. There remains the possibility, as Justice Harlan suggests, that important testimony of witness unavailable at the trial could have been preserved had counsel been present to cross-examine opposing witness or to examine witness for the defense. If such was the case, petitioner would be entitled to a new trial. Justice Harlan concurring in part and dissenting in part. If I felt free to consider this case upon a clean slate, I would have voted to affirm these convictions, but in light of the lengths to which the right to appointed counsel has been carried in recent decisions of this court, see Miranda v. Arizona, U.S. v. Wade, I consider that course is not open to me with due regard for the way in which the adjudicatory process of this court, as I conceive it, should work. While given the cases referred to, I cannot escape the conclusion that petitioners' constitutional rights must be held to have been violated by denying them appointed counsel at the preliminary hearing. I consider the scope of the court's remand too broad and amorphous. I do not think that reversal of these convictions for lack of counsel at preliminary hearings should follow unless petitioners are able to show on remand that they have been prejudiced in their defense at trial. In that favorable testimony that might otherwise have been preserved was irretrievably lost by nature of not having counsel to help represent an affirmative case at the preliminary hearing. In my opinion, mere speculation that defense counsel might have been able to do better at trial had he been present at the preliminary hearing should not suffice to vitiate a conviction. The court's remand under the Chapman harmless error rule seems to me to leave the way open for that sort of speculation. Stewart, with whom Chief Justice joins dissent. If at the trial the prosecution had used any incriminating statements made by the petitioner at the preliminary hearing, the convictions before us would quite properly have to be set aside. But that did not happen in this case. Or if the prosecution had used a statement of any other witness at the preliminary hearing against petitioners at the trial, we would likewise quite properly have to set aside these convictions. But that did not happen in this case either. For as the court today perforce concedes, the prohibition against use of state at trial of anything that occurred at a preliminary hearing was scrupulously observed. The court holds, I don't know what this perforce word means. Perforce, one word. Like perverse. I'm kidding, I don't know what that is. The prohibition against use by the state at trial of anything that occurred at a preliminary hearing was scrupulously observed. But the court holds today that the Constitution required Alabama to provide a lawyer for the petitioners at their preliminary hearing, not so much, it seems, to assure a fair trial as to assure a fair preliminary hearing. A trial at the preliminary hearing, the court says, might have led the magistrate to refuse to bind the accused over, or a lawyer might have made effective arguments for the accused on such matters as bail or the necessity for an early psychiatric examination. If those are the reasons a lawyer must be provided, then the most elementary logic requires that a new preliminary hearing must now be held with counsel made available to the petitioners. In order to provide such relief, it would, of course, be necessary not only to set aside these convictions, but also to set aside the grand jury indictments and the magistrate's orders fixing bail and binding over the petitioners. Since the petitioners have now been found by a jury in a constitutional trial to be guilty beyond a reasonable doubt, the court understandably boggles at these logical consequences of its own reasoning. It refrains, in short, from now turning back the clock by ordering the preliminary hearing to determine all over again whether there is sufficient evidence against the accused to present their case to a grand jury. Instead, the court sets aside these convictions and remands the case for determination whether the conviction should be reinstated or a new trial ordered. In this case, action seems to me even more quixotic. No record or transcript of any kind was made of the preliminary hearing. Therefore, if the burden on remand is on the petitioners to show that they were prejudiced, it is clear that the burden cannot be met, and the remand is a futile gesture. If, on the other hand, the burden is on the state to disprove beyond a reasonable doubt any and all speculative advantages that the petitioners might conceivably have enjoyed, if counsel had been present at their preliminary hearing, then obviously that burden cannot be met either, and the court should simply reverse these convictions. All I can say is that if the Alabama courts can figure out what they are supposed to do with this case now that it has been remanded to them, their perceptiveness will far exceed mine. The record before us makes clear that no evidence of what occurred at the preliminary hearing was used against petitioners at their now completed trial. I would hold, therefore, that the absence of counsel at the preliminary hearing deprived the petitioners of no constitutional rights. Accordingly, I would affirm these convictions. And so the Justice Berger is dissenting. I agree that as a matter of sound policy, counsel should be made available to all persons subject to the preliminary hearing, and that this should be provided either by statute or by rulemaking process. However, I cannot accept the notion that the Constitution commands it because it is a criminal prosecution. Certainly, as Mr. Justice Harlan and Mr. Justice White suggest, not a word in the Constitution itself either requires or contemplates the result reached. Unlike them, however, I do not acquiesce in prior holdings which purportedly, but nonetheless erroneously, are based on the Constitution. That approach simply is an acknowledgement that the court, having previously amended the Sixth Amendment, now feels bound by its action. Court having previously... while I do not rely solely on 183 years of contrary constitutional interpretation, it is indeed an odd business that it has taken this court nearly 2 centuries to discover a constitutional mandate to have counsel at a preliminary hearing. There is not even the excuse that conditions have changed. The preliminary hearing is an ancient institution. If the Constitution provided that counsel be furnished for every critical event in the progress of a criminal case, that would be another story, but it does not. In contrast to the variety of verbal combinations employed by the majority to justify today's disposition, the Sixth Amendment states with laudable precision that in all criminal prosecutions, the accused shall have the assistance of counsel. Emphasis added. The only relevant determination is whether a preliminary hearing is a criminal prosecution, not whether it is a critical event in the progress of a criminal case. By inventing its own verbal formula, the court simply seeks to reshape the Constitution in accordance with its own predilections of what is desirable. Constitutional interpretation is not an easy matter, but we should be especially cautious of substituting our own notions for those of the framers. Under today's holding, we has something of an anomaly under the new discovery of the court that counsel is constitutionally required at the preliminary hearing, since counsel cannot attend a subsequent grand jury inquiry, even though witnesses, including the person eventually charged, may be interrogated in secret session. If the current mode of constitutional analysis subscribed to by this court in recent cases requires that counsel be present at preliminary hearings, how can this be reconciled with the fact that the Constitution itself does not permit the assistance of counsel at the decidedly more critical grand jury inquiry? Finally, as pointed out, the court has already protected an accused from absence of counsel at the preliminary hearing by providing that statements of an uncounseled person are inadmissible at trial. The court fails to explain why that salutary, indeed drastic remedy is no longer sufficient protection for the for the preliminary hearing stage, unless what that court is doing surreptitiously is to convert the preliminary hearing into a discovery device.